It's a privilege to be here today at the University of Oregon Law School. It's a place that I know and love. My legal director at the Center on Race, Poverty, and the Environment, Brent Newell, is a proud U of O Law School alum, class of 2000. And I've been up here a number of times for the Public Interest in Environmental Law Conference. What I'd like to talk about this afternoon are two concepts that I have yet to even hear mentioned in the course of our conversation this morning. The first is environmental justice, and the second is litigation. This being sponsored by the Journal of Environmental Law and Litigation, I figured there'd be a little more on litigation, but I feel it's my duty to inject just a little bit of litigation into our conference proceeding. As context for what I'm going to talk about, I want you to think for a minute about the distribution of environmental hazards in the United States. Environmental hazards in this country are not equitably distributed. For every environmental hazard that you can think of, air pollution, water pollution, pesticide poisonings, lead poisoning, proximity to toxic waste dumps, poor people and people of color have a greater exposure, bear a greater burden than richer people and white people. That national disparate impact has given rise to the environmental justice movement, which is a vibrant social movement of people directly affected by environmental hazards. And I'm going to swing back around to the environmental justice movement a little later. How does this disparate impact play itself out with energy? Well, let's take our largest energy input, oil and gas. Where do we get it? Whose land does it come from? If you want to look at drilling in Alaska, it's Native Alaskans. Many of the places that we extract our energy for our economy are on native lands. Where do we refine it? I don't know if there are any actual oil refineries in the state of Oregon. But in my home state, in California, the refineries are clustered in identifiable communities. Richmond, Martinez, Wilmington. All of these communities share similar demographics. They are low-income communities, and they are almost entirely communities of color. So where we get it, where we refine it, how about where we use it? What are major places where we use energy? How about power plants? Where are power plants sited? If we look across the United States at the siting of power plants, we see that they are disproportionately distributed in communities of color and low-income communities. Let's take another way we use energy, which many people don't think about in terms of having a disparate impact, but transportation, cars and trucks. Who lives next to freeways? It's mostly not the rich white folks. There's a reason there's the expression, the wrong side of the tracks. Where do the tracks go? Okay? So where we use energy at power plants and in transportation also has a disparate impact. Where do we dispose of the byproducts of oil refining, and our use of petrochemicals? Toxic waste dumps. The siting of toxic waste dumps is highly correlated to low-income communities, communities of color. Almost all aspects of our energy economy thus have environmental justice implications. That impact carries over directly into the climate change context. Let's just look at a couple of the impacts from climate change that we're already seeing. Heat deaths. Heat deaths and heat waves have a disparate impact on poor people and people of color. You may not think about that, but when you look at where we've had major heat waves that have killed hundreds of people in urban areas like Chicago, has a grossly disparate impact on the basis of race. Black people in Chicago died at much higher levels proportionately to their population than white people during the heat wave several years ago. And also income. This is for a couple of different reasons. First is, if you're poor, you may not have an air conditioner. An air conditioner is a pretty good adaptive technology to heat. It's not terribly good in that it uses more energy and causes more pollution and causes more global warming in the end. It's not a good adaptive technology societally, but individually, if it's hot, you want an air conditioner. Poor people are less likely to have them. Urban areas create heat islands, too, which drive up the heat, making urban areas have a disproportionate impact from heat versus rural areas. You also have a situation where in the Chicago heat wave, for example, there were many elderly people who would not open their windows because of security concerns in the particular neighborhoods they were lived in, and they ultimately died because of the heat. So where you live directly influences how you're experiencing one of the major predicted impacts of global warming, which is indeed warming. It's going to be hotter. There are going to be more heat waves. Disparate impact. Second, let's look at natural disasters. I'm going to say one word about the disparate impact of natural disasters on poor people and people of color. And we can leave it at that. That word is Katrina. Okay, Katrina is the wake-up call for us to show us that unless we plan very carefully around disaster preparedness and disaster response, when we have these catastrophes, which in the Katrina situation were not catastrophes of nature, they were human-created catastrophes, poor people and people of color are going to suffer disproportionately. Let me look at one more area. Air pollution. Currently, air pollution is not equally distributed on the basis of race and class. Richer people can buy access to cleaner air. That's the bottom line. With global warming, we are going to have more air pollution. Ground level ozone, or smog, is formed in part by heat and sunlight. So the predictions are that urban air pollution and air pollution in already polluted areas is going to increase as we go forward. So you have all of these disparate impacts. What can you do about it? Well, I want to talk about one particular case that the Center on Race, Poverty, and the Environment has brought on behalf of the native village of Kivalina. Before I do that, though, because this is a conference sponsored by the Journal of Environmental Law and Litigation, I want to take 5 minutes and give you Climate Change Litigation 101. There have been more than 100 lawsuits filed that you could put into the category of climate change litigation. They fall into 4 basic conceptual boxes. And I'm going to focus on the 4th box, but I'm going to tell you what the other 3 boxes are. So when you leave here, you'll get your continuing legal education credits for knowing all about climate change litigation. Box number 1, information forcing lawsuits. Information forcing lawsuits. These are lawsuits typically under the National Environmental Policy Act, or in my home state, the California Environmental Quality Act, against jurisdictions that are making land use decisions, local, state, federal government, asking those jurisdictions, or trying to get the court to force those jurisdictions to provide more information on the climate change impacts of a particular policy or land use decision. Information forcing lawsuits. Some of them have been successful. Some of them have been successful on other grounds in stopping particular projects. Some of them have not been successful. But that's the first conceptual box. The Center for Biological Diversity has kind of led the way in this type of lawsuit in California. Surf their website, you'll see a number of information forcing lawsuits. The second conceptual box is action forcing lawsuits. Beyond demanding that the government disclose the climate change implications of its decisions, there have been a number of suits that have sought to force the governments, local, state, federal governments, to do something. The iconic one in the climate change litigation field thus far is Massachusetts versus EPA, where the state of Massachusetts and a number of other jurisdictions sued EPA saying, EPA, you have got to do something about carbon dioxide. Court, step in and force some action. Action forcing lawsuits are our second box. Our third box are action stopping lawsuits. These are suits by regulated industry, almost entirely car dealers, interestingly enough, against jurisdictions to stop some action being taken to address climate change. California has a unique position under the Clean Air Act as being able to have stricter air pollution control laws than the federal government. And then under the Clean Air Act, other states can adopt either the federal floor or they can follow California's lead. California sought to regulate vehicle mileage to attack climate change several years ago, and the auto dealers sued every jurisdiction, including California, that adopted California's plan. Rhode Island, Vermont, New York. The auto dealers' suits were universally unsuccessful in court. But because the Bush administration did not grant California's request for a waiver from the Clean Air Act, the auto dealers have thus far been successful in not having any states roll out this new program. So action stopping suits have not been legally successful, but the policy that they embody has been politically successful under the Bush administration. That's the third conceptual box. Fourth conceptual box, damages suits. Damages suits. These are suits against polluting industry to recover the damages that global warming is causing to the plaintiffs. 4 suits so far. First suit, very interesting suit, State of Connecticut sues American Electric Power and 4 or 5 other defendants, all of which are power companies in the southeastern United States. And I say 4 or 5 other defendants, not because it's unclear how many defendants there are, but because it's unclear whether American Electric Power and one of the AEP subsidiaries, who is also a defendant, are 2 companies or 1. So 5 or 6 defendants in the suit. And says to the federal district court in the Southern District of New York, court, we want you to step in and provide us with injunctive relief against these power companies because their emissions are causing global warming, which is causing harm to us. We think they're emitting too many greenhouse gas emissions, and we want you, Madam Justice, to step in and do something about it. The judge in that case said, on her own volition, it was not in any of the briefing by the parties, hey, this is a political question. You are asking the wrong branch of government to regulate emissions levels from power plants, all right? We have branches of government that are uniquely suited to this, that have the expertise and the resources to do this type of thing. And they're not the judicial branch. They are the executive branch and the legislative branch. I'm throwing you out, Connecticut. Connecticut versus AP, seeking injunctive relief, tossed out by the district court, currently up in the Second Circuit. All of us who are climate litigation wonks have been closely watching the Second Circuit for more than 2 years as this case has just been there under submission. It's been argued, briefed, everything for more than 2 years, and things are just kind of grinding along. I don't know what they're waiting for, but we're waiting for them. Second case. Comer versus Murphy Oil. Comer and 10 other plaintiffs sue a constellation of defendants because their homes on the Mississippi coast were destroyed during Hurricane Katrina. They make the following argument. All of you people, from insurance companies to oil companies to, who knows, huge long list of defendants, caused global warming. Global warming caused Hurricane Katrina. Hurricane Katrina caused us to lose our homes. Now, 2 elements of that chain of causation, one might have a chance of showing in court. These companies are contributing to global warming. I think that's a step that we're hoping to get courts to make in one of the other lawsuits that I'm going to talk to you about in a sec. And Hurricane Katrina destroyed their homes. Undeniable. Global warming caused Hurricane Katrina. Huge conceptual leap. I don't think any court is going to go there on the facts we've got now. The judge, taking a look at Connecticut versus AP, decided by the learned court in the Southern District of New York, tosses this one out, says, it's a political question. Get out of here. Against the recommendations of counsel around the country, the Comer's attorney filed an appeal in the Fifth Circuit Court of Appeals. Those of you who are environmental or civil rights or social justice or education reform or voting rights or death penalty, anti-death penalty advocates, know that if there's one place you want to not be if you are seeking to make good law, it is the Fifth Circuit Court of Appeal. Comer's currently on appeal in the Fifth Circuit. I think they're going to dispatch it very quickly, and because factually it is distinguishable from the other three cases, we don't have to worry about it. Third case, California, state of California versus General Motors. Just as a sidebar, what is the theme you see here? Leave Comer versus Murphy Oil out, because I think that's a dog of a case. States. Why are states suing people? Massachusetts versus EPA, Connecticut versus AEP, California versus GM. Why are states suing people?
It's costing them money.
It's costing them money, and who's supposed to be dealing with this and isn't? The feds. We have no national climate change policy except to not have a policy. And so it's been left up to 50 different states to do what they can to try and cobble together a policy, using the very blunt policy tool of, in some cases, litigation. California versus GM, novel theory. State of California says, we are experiencing global climate change that is having catastrophic and very expensive impacts on our snowpack. We have to rejigger the entire way we collect and distribute water in the state of California. It's going to cost us hundreds of billions of dollars. GM and these other 5 car companies are creating products which, when used in the way they're designed to be used, go out and emit greenhouse gases, which are causing global warming that's causing our damages. All right? Now, putting aside the potential problem of unclean hands, which is that the state of California probably has the largest vehicle fleet of any state in the United States, and they bought them all from these car companies that they've sued, and they're out there busily driving them around, creating the emissions they're suing over. Put that aside, and put aside the fact that the state of California has granted permits to the factories that are producing the cars. Put that aside, because that wasn't really an issue in what caused this case to go off the rails. Judge Martin Jenkins of the Northern District of California, with his eye on Connecticut versus AEP, checked out the case. Said, political question. All of the defendants, now having learned that political question was the winning defense, argued, this is a political question, Your Honor. There are other branches of government that are far better equipped to handle this than the judiciary. It was tossed out last year. It is currently on appeal in the Ninth Circuit. Now, those of you who are environmental plaintiffs' lawyers, death penalty lawyers, civil rights lawyers, whatever, you know that one of the circuits, along with the Second Circuit, interestingly enough, where you like to be, not so much in recent years, but historically where you'd like to be is the Ninth Circuit. So we have high hopes for this case. The fourth case is a case that I'm familiar with because I'm the lead counsel. Native Village of Kivalina and City of Kivalina versus ExxonMobil and 23 other greenhouse gas emitters. The Native Village of Kivalina is a subsistence hunting and fishing village north of the Arctic Circle on the Chukchi Sea. It is way the heck up there. It's just south of the Arctic Ocean, north of the Bering Sea, on the coast. It's a community of about 400 Inupiaq Eskimos. The way that they gather their food is they go out on the ice in the winter and they hunt seals, they hunt walrus, they hunt whale. They go out on the ice over the tundra using the rivers, the frozen rivers as their highways on their snow machines. They used to do it on dog sled, now they do it on snow machines. And they hunt caribou in the winter. And then in the brief summer, they fish. But they're basically landlocked. They have boats. They're on an island. They're basically landlocked during the summer when the ice is melted, and then they have total mobility and freedom to travel around when there's ice. Big storms in the Arctic, particularly on the ocean, but Kivalina had always been protected from those storms by the ice. Starting in late September, early October, you would get kind of slush in the water, and then towards the end of October it would freeze up and start freezing to the land, so you'd have land-fast ice, which would go for dozens, sometimes hundreds of miles out across the Chukchi Sea. When the winter storms came, they would blow across the ice, blow across the village, and nothing big would happen. The hunters could use the ice to go out and hunt from. They would find cracks in the ice and wait for the mammals to come up and get them. Well, as all of you I'm sure know, one of the central consequences of global warming in the Arctic is that mean temperatures have gone up dramatically. Mean temperatures around the world have gone up maybe a degree. Mean temperatures in the Arctic have gone up about 8 degrees. Huge, huge temperature rises. So that where you used to have land-fast sea ice in late October and early November, when I was up there in January of this year, there was no sea ice. So when the winter storms come, rather than hitting the edge of the ice, way, way out at sea, they have 100 miles of fetch to build power, and they come crashing in as enormous waves, and they're just chewing through the island. As part of this perfect storm of climate change, the island, which has largely been permafrost, which is frozen dirt, basically, the permafrost is now melting. So whereas before the waves would hit the permafrost, which is like hitting a rock, now they're hitting melted permafrost, which is sand and dirt, and they're just chewing it away. The consequence of global warming is that the island that the city of Kivalina exists on is being eroded dramatically. It's lost 25% of its width, which is about 200 or 300 yards. That's the whole island. It's lost maybe 100 yards in the last 5 years. The community has to relocate off the island to the mainland. The Army Corps of Engineers and the Government Accountability Office have estimated that this is going to cost between $150 and $400 million. Now, the bridge to nowhere in Alaska was $187 million to build a bridge to a community of 1,500 people. Mocked and ridiculed. How about moving the Eskimo village from nowhere to nowhere else for $400 million? You think we're going to get that one through Congress? I think that's going to be a tough sell. We're going to try, but that's going to be a tough sell. So, working with tribal leaders in the native village of Kivalina, whom I've represented for the last 6 years in a mining dispute, totally separate from this, and trial lawyers from around the country, several of whom were involved in the big tobacco litigation, we devised this litigation strategy to sue 24 of the largest greenhouse gas emitters in the country. The idea was to go after the people who had actually caused the problem. Now, how are we going to avoid Connecticut versus AEP? We're not asking for injunctive relief. We're not asking the judge to set emissions levels. We're asking the judge to do something that judges do all the time, which is determine damages. The damages are finite, they're easily ascertainable, they have been documented by the General Accountant, the Government Accountability Office, and the Army Corps of Engineers. How are we going to not suffer the fate of California versus GM? We have a much more sympathetic plaintiff. No unclean hands. The Eskimos of the Arctic have done probably as little as almost any other people on Earth to contribute to the problem of global warming, and unfortunately, they are bearing the burden of global warming. They are the canaries in the coal mine, as it were, of dramatic climate change. So we think we have sympathetic plaintiffs. We have also included a claim for conspiracy, because ExxonMobil and 5 of the other defendants, the defendants here are big power companies, Peabody Coal, and big oil companies, major direct greenhouse gas emitters. 6 of these companies, we allege, have conspired to mislead the public about the causes and effects of climate change. ExxonMobil and 5 of the other defendants have funded and continue to fund junk science, nutso think tanks, and conferences that bring together climate skeptics and doubters to cast doubt on whether climate change is happening at all. Everybody now largely concedes that climate change is happening, even the learned governor of Alaska. She has to, it's happening, she sees it every day, you know. You walk down the street in Fairbanks and the trees, the drunken trees, because the permafrost is melting. Whether it's happening at all, and we've now finally largely won that question, but whether human activities are causing it. The conspiracy claim is not something that can really be tossed out on political question grounds, right? Conspiracy claims are not decided by the legislative or executive branches of government. They're decided by the judicial branch. As you might expect, all of the defendants filed motions to dismiss this summer. We have filed our opposition to the motions to dismiss in this case, and the case is scheduled to be heard on December 9th in the Northern District in Oakland, California. I think it's unlikely it'll be argued on that date because the volume of briefing is gigantic, and I'm sure the judge will probably kick it off into the new year. But when you hear about that case, you'll know, are we making inroads? Did we survive a motion to dismiss? Because that's the first step. Then there'll be discovery, and then there'll be motions for summary judgment. And if we survive motions for summary judgment, then there'll be a trial. We are a long way from the goal line in this case. And Steve Berman, one of my co-counsel who did a lot of the plaintiff side tobacco litigation, said, and I'm going to misremember the exact number, but he said, we won the tobacco case on the 783rd case that we filed. Kivalina versus ExxonMobil is number 4. My hope is that the tobacco litigation is not the model that we're going to be following. My hope is that the Holocaust reparations cases are going to be the kind of development of the law model we're going to follow. Those cases were brought in a number of jurisdictions. They were universally dismissed at the trial court level. And then when they went up to the courts of appeal, the courts of appeals said, wait, no, these are good cases. You shouldn't be tossing these out, trial courts, including the Ninth Circuit and the Second Circuit. You shouldn't be tossing these out. They went back to the trial courts, and most of them very quickly settled. That's the model we're looking for, so we don't have to go through 780 more of these cases. We can move more quickly towards getting some type of solution in court. Litigation remains the blunt tool. And I think what you're hearing from all of the other panelists is that policy, both on the local and state level, and starting in January, no matter who's president, on the federal level, is really the answer to climate change. But if there's a takeaway to this, it's that when you are implementing that policy, I want you to remember the 2 words, environmental justice, because climate change has dramatic environmental justice consequences. And unless we set out to make our policy shift reflect that and mitigate that, we are going to continue to cause environmental injustice as we go forward. So my challenge to you is go out there, do great climate change work, and make sure that environmental justice is a central part of it. Thank you. I am passing, before we get to questions, I've passed around a sheet. If you'd like to get on our mailing list to hear the latest news when this case is thrown out and we appeal it to the Ninth Circuit, or more about what we do, we provide legal and technical assistance to communities around the country. We have 7 lawyers in San Francisco and Delano, California. We take summer interns. A number have come from the University of Oregon. We have 4 organizers in our Delano office. If you'd like to be on our emailing list, please sign up and just make sure that gets back to me. Questions? Yes, Mr. Bonine.
I've got a couple. One is, in any of the previous litigation, whether tobacco, Holocaust, or other, has the funding of conferences and of junk scientists been successfully used as part of the claim? And the second one is, obviously, if you survive the motions to dismiss, then the fund begins, and I'm sure it's not your intention, but I presume that the material uncovered during discovery could have great political implications in this country, not just court implications.
The answer to your first question is, has junk science been successfully used, is I don't know the answer to that. Certainly, the junk science around tobacco came to light as a result of discovery during the tobacco litigation and was used widely and really shifted policy dramatically when it became clear that it wasn't, gosh, nobody knew, to, wow, people did know and they still profited by killing people for another, several decades. That type of discovery, which we would hope to get out of this litigation, I think, as you say, could have dramatic political ramifications as well.
But the claim is a conspiracy to pollute, not a conspiracy to lie, isn't it?
No, it's the conspiracy, well, it's both. It's the conspiracy to lie and mislead the public so we can continue polluting without any public interference, without the public rising up and not buying our products because we're such big polluters.
But has that conspiracy to lie for the purpose of achieving political goals been the subject of any of this previous litigation?
I don't know that. It's an excellent question, Professor. That's why you should be up here.
Are you going to be using any of their environmental commercials as proof of their conspiracy?
In the conspiracy claims, and the lawsuit, I think the lawsuit is probably available online. I mean, it's a big, fat, hefty document. We raise a number of their own kind of greenwashing commercials, and we certainly will be using their own words against them, hopefully to great effect. Yeah, Alexander.
Where does the $400 million relocation fee come from? It seems pretty high for 400 people.
Construction in the Arctic is very, very expensive. You have a very limited season, and you are basically creating a whole new community. Now, the native village of Kivalina, right now in the year 2008, does not have running water. This is in the United States of America. They do not have running water. They use honey buckets as their system of sewage disposal, which is basically a 5-gallon bucket with a toilet seat on it and a plastic bag, and when it's full, you tie it up and you drive it out on your snow machine to the dome. Constructing sewage facilities, water lines, things like that in a whole new community is very expensive. The primary expense is actually a gravel pad. Most Arctic villages are built on gravel pads because they are not subject to the same subsidence that the permafrost is. So it's just very expensive to construct things there. That's the upper limit, it's 150 to 400 million. But that's what all of the studies say. Svetlana?
My question is, you started from environmental justice, and then you jumped to these climate change cases. Are you going to use this concept somehow in the court? I mean,
Well, environmental justice for us at the center is working with communities that are directly experiencing environmental hazards to have them at the table when the decisions about solving those hazards are made. And so the Kivalina case for us is definitely an environmental justice case. There are few more impoverished communities of color than the native village of Kivalina. And we wanted to be sure that they were at the table when these decisions were being made, because as the cliche goes, if you're not at the table, you're going to be on the menu.
So it's public participation.
It is partially public participation. They are suddenly media darlings. They have a bunch of European press coming in. The story on our case was in the New York Times. And so now when people think about village in the Arctic climate change, they think Kivalina. So that's been an important part of it. One more question.
Is there any smoking gun kind of evidence that is available at this point, or are you just hoping to kind of in discovery to find some incriminating memos or things that?
There are a lot of studies by these bogus think tanks funded by ExxonMobil and other defendants that say basically the earth is flat, the moon is green cheese, there is no climate change happening, you know, there's a whole orchestrated campaign, and there is the smoking gun memo that says we will have won a victory if we can make the American public doubtful on whether climate change was caused by humans or not. And they have been successful in that, to the extent that when we were working with the village leaders in Kivalina, a number of them are like, well, this could just be a natural cycle. We don't know if humans are creating this. I mean, it's been a very effective public relations campaign that we need to strip away. Do we have time for more? Okay, we'll go in the back.
You spoke a lot about how the political question theory that the other damages cases have been thrown out on is one that you're working to avoid.
We have not avoided it. All of the motions to dismiss are on political question grounds, among others, so we are confronting it squarely. Yeah.
That was kind of my question, is that all the motions to dismiss have political question, but they have a lot of other stuff in them too, and I'm wondering if there are other claims that were raised on motions to dismiss that concern you and why that might be, is something the judge can pick up on. And
There are the basic, you know, there are jurisdictional defenses, there's standing defenses, there's, you know, various forms of failure to state a claim defenses. I don't think any of those are particularly strong. I mean, if the native village of Kivalina, which is a federally recognized Indian tribe, doesn't have standing to sue for public nuisance when its village is being destroyed, I can't imagine who does have standing. So I don't think that those points are, the other defenses are well taken. And I don't think the political question point is well taken either. It's just thus far been the successful bullet that the other side has had in these cases. But I'm hoping that the Second Circuit someday soon is going to come down and say, you know, District Court, you got it wrong on the political question, and we're going to let this case go to the next round, at least, to do some discovery. So, though unfortunately, the Second Circuit case is the injunctive relief case, and there, just in terms of a gut level case, you could say, I understand how the court felt that she didn't have the experience to set emissions levels at power plants throughout the southeastern United States, that some other branch of government might have that experience and expertise. That's our least strong case on that kind of gut level one among ours, California and Connecticut. One more question.
I wondered if you needed psychological evidence that their message actually got across. I think it seems to be a bit of a leap, maybe not one for a lot of us, that to say that they played these commercials over and over and over again, and then we had no action on kind of congressional or even state levels. Do you need another step in there where you have an expert psychologist say that, these commercials have an effect, that, you may not quite link it up with the politics, but you can actually influence X number of people with X number of commercials, or X amount of junk science, X amount of press releases?
You raise something that gets into the nuances of this field of conspiracy. There's something called the Pennington Doctrine, which basically says that if you're a corporation and you're trying to influence decision makers, not the public, decision makers, you can say pretty much what you want. All right? That's the marketplace of ideas, and under Pennington, that is not actionable. That's not, we are not saying they had a conspiracy to fend off congressional regulation. We can't say that successfully under Pennington, though there are a number of exceptions to the Pennington Doctrine that definitely apply here, like if you're lying to Congress, you don't get a get-out-of-jail-free card under Pennington. But our claim is that they were lying to the public so that the public would not change its buying habits or, rise up and revolt against ExxonMobil for destroying the planet. That's the claim. And I don't know, I don't think we need a psychologist to show that, but we will, when we get to that stage.
Lying was effective or effectual? Is that, or is the action just in the line itself?
I think the action is in the lying itself, because the conspiracy was to lie about it, not to make the lie effective. So, thank you.